The counties created 25 years ago when they couldn't buy insurance anymore from the standard market. The insurance companies just would not insure counties, cities, school districts all across the nation. So here in Utah, just like they did all over the nation, those government entities had to create their own insurance companies to cover themselves, or pools as they're referred to. And so all the counties put money into the fund each year based on what we think our losses are going to be for the coming year, that the actuary takes a look at and pegs what we think we're going to have for losses based on past history. And then as cars get banged up, buildings burn down, lawsuits get filed against the county, we take money out of the fund to take care of all of those types of losses. So what we're doing today is trying to reduce the numbers of claims that we end up with. And in the ethics area, you'll see that the violations really are more individual against the individual employee or officer. But many times, these types of ethics violations will then turn into a lawsuit against the county proper because the person's rights were violated in addition to the acts being violated. So as we go through today, just ask questions as we go. What we're want to try and do today is review the statutory prohibitions, limitations, and requirements that relate to ethical behavior of public officers and employees and people that interact with you as employees of the county. The prohibitions and limitations and requirements aren't all consolidated into one nice, neat, and tidy law. They're found throughout the statutes. What I'm going to do today is focus on really two primary areas of statute that speak to ethics laws, and two others that are pretty important to consider. A lot of it duplicates what's in the first two, but it just adds to the penalties that you will have if you are in violation. Morning, Rodney. So first of all, when we talk about ethics, we're really talking about moral principles. We're not talking about the standard types of laws that guard against one person injuring another. We're talking about something that just doesn't feel right and doesn't seem to be appropriate. And of course, those morals really change from one place to another. I was meeting with some Chinese businessmen just a few weeks ago at a national conference, and still in their country, for a government official to take money to help someone get something done through the government is perfectly fine. That's the way they do business. It's not a violation of the statute. As we know, here in America, that is not appropriate. The legislators feel that you get paid as a county employee or as a government official in your elected capacity, and that is the one and only type of compensation that you should receive for doing any type of business with the county. And you shouldn't get other gifts, compensation, that sort of thing, just because you are a government employee. So because of that, because these ethics laws are really more based on what people feel is right or wrong, they're changed all the time. Many of the things we'll talk about today weren't in the statute 10 years ago. But the legislature has, they created the Ethics Act about 10 years ago, and they've played with it just about every year since. Either with adding new things that are going to be a violation, making exceptions, usually for themselves, to the prohibitions, and or changing the penalties that arise as a part of these. So the funny thing about this is many of these ethical violations come to the determination of whether or not you have a conflict of interest in your private dealings and your employment or position that you hold with the county. But the statute doesn't really define specifically what a conflict of interest is. You're just supposed to know what that is. One thing that it does do is the statute does apply to both actual or potential conflicts of interest between public duties and private interests. So something that you do outside of your employment that affects your decision-making or potentially could affect your decision-making in your capacity as a government employee or official is considered to be a conflict of interest. Now, when I read the statute in its literal form and the way that you're supposed to read a statute, potential conflict would seem to mean that an actual conflict of interest is not occurring right now, but given the right circumstances down the road, it's very likely that that conflict will occur. You own a company that might do business with the county in the future. The type of business that that company does, the county regularly seeks to hire people to do that type of business. And you've just bought this other business. You've gone in with some family members and bought this business. There's a potential for conflict down the road when you start bidding on work for the county, right? So that to me is what is meant by the potential conflict of interest. The problem is that recently the Political Subdivisions Ethics Committee, which is the entity that the state created that hears these allegations of ethics violations to determine whether or not you violated the act, when they looked at potential conflict, they more or less found potential to mean anything that somebody dreams up that they think would be wrong if it happens in the future with you, and which is clearly, in my mind, not what the legislature meant by potential conflict, but it really makes it difficult for you as a county employee or elected official because that group really has all the power. They can subpoena you and all of your records, your emails, your text messages. You have to come to court if they want you to, or come to their hearings if they want you to. They can subpoena other witnesses, your family members and business partners, your coworkers, and they have to show up, or they can find you in contempt of court and charge you contempt charges, throw you in jail. I mean, they have an extraordinary amount of power for some commission that the state created, that none of the members are voted into their positions. They're appointed by the legislature. So actually, I'm working with the County Attorneys Association to take a look at that commission to determine whether or not that's really the way that we want alleged violations of the Ethics Act to be determined. The statute does allow for an individual county to create their own ethics committee to hear violations of the act. And if the county creates a committee, then all allegations within that county go to that county's commission, not to this statewide commission. The problem there is most of the commissioners I talk to say, well, what would be the use? I mean, a group of people here in our county are going to hear alleged violations of the Nepotism Act about one employee that's related to another employee and whether or not that's a violation of the act. No one's going to believe that that committee doesn't know those people well enough that they're going to hear that issue fairly. So one of the ideas that we have through the association is that we would create some regional committees to hear these violations that are put together by the Association of Counties, that we would find former judges and things like that to sit on those committees and really make sure that they follow the law. Because so far, this Political Subdivisions Ethics Committee has only had one violation that they have heard against a county employee, and clearly they did not follow the law at all. The AG that was assigned to them to oversee their workings, when I and some of the county attorneys met with them to find out how did they arrive at the findings that they did, there's several things that they penalized this employee for that aren't even violations in the act anywhere. Clearly in the act, they aren't violations. And the response was, well, I told them that, but they just felt like they had to send a message. So I say that because this area is very tenuous. The penalties are pretty darn severe, as we'll see in a second. And so you want to be very careful whenever you're talking about a potential conflict of interest, that somebody else might see what you're doing as a potential conflict.
Have they seen other cities or any other, I mean, you mentioned that this is a county employee, have they seen city employees or state employees? This is just one.
Just one so far that it's gotten to that level, because there are some stages before they actually do a full hearing where they look at the evidence that's provided and determine whether or not, just on the basis of what the allegation is it a violation, or is it something that can be cleared up some other way rather than having a full hearing on it. This one situation was the only time that they've had a full hearing, and it probably had a lot to do with there were several people who made allegations. As soon as one person found out that this committee exists, they got all their friends and neighbors to file complaints as well. So it became a bigger deal. And it was something that looked really good in the newspapers. So, you know, that kind of drove the committee to doing a full-blown hearing as well. Okay. When you look at the legislative intent, and these laws are just old enough that they still had legislative intent built into the statute, it's to promote the public interest and strengthen the faith and confidence of the people of Utah in the integrity of their government. If they can see what you're doing, and if they know that, well, I know that this elected official works for the county, but they also work for a company or have a job with a company, or they have interest in a company that does work for the county, there's got to be something funky going on there. If they can see that there's laws that require that official to disclose that information or may prohibit them from doing that act, they feel more confident in their local government. It's interesting that in the intent, it clearly says that it doesn't intend to keep a public employee or officer from being able to do and have interests outside their county job. That's not the intent, is to keep you from having other interests. It's only to keep you from having other interests that negatively impact your faithful discharge of your public duties. So that's the tipping point, supposed to be the tipping point. Okay? Even though, again, in this one situation, the elected official, clearly the things that he did, there were several things that he was found to have been in violation for that didn't have anything to do with his public duties. You know, he's part of a family trust fund that owned property, and he was the recorder. And he didn't disclose every time that parcel, you know, had any action taken on it, that he was part of the family trust, and they found that to be a violation. Clearly it wasn't, but the committee found that it was. Because they wanted to send a message to other recorders to be more careful. So again, that's the intent of the legislation, but again, when you get to execution, it's much like this cartoon that, you know, the Department of Governmental Transparency, you know, you try and determine exactly what it is that they're prohibiting or limiting, and you go from one statute to another, and some of these are really tough to figure out exactly what is it that I have to do if I'm in this situation. Hopefully you'll get a little bit of that from me today, but if you find yourself in a situation that sounds like what we talk about, you want to talk with the county attorney or your own attorney for the business that you're doing business with to make sure that you're not in violation. This is one of those situations where, as a government employee or official, in that capacity, the county attorney is, you know, he's not your personal attorney. He has to look out for the county, but in the end, once this political subdivision's ethics committee finds that they believe that you've violated the act, the county attorney is required to be the one that moves through the process to discharge you from your employment and file criminal charges against you. So it puts the county attorney, that's another reason why the county attorneys are working with us to make some changes to these laws, because that puts them in a real conflict that you're a government official, county official, you're supposed to be able to go to the county attorney if you are charged with something or are supposedly in violation of something in your official capacity, but yet you can't go to the county attorney because he's the one that's supposed to bring the suit against you. So we'll work on that and try and get that cleared up. So again, ethics laws are found in several different statutes. The two primary ones that we'll talk about today are the Utah Public Officers and Employees Ethics Act, Title 67, which most people think is the ethics law. That if I'm okay with, under that act, if I'm not violating anything there, I'm okay. But the problem is there's also the County Officers and Employees Disclosure Act, which cites several different prohibitions, that things you can't do, and several things that you can do, but only if you disclose that you're doing it, that you have that other conflict. Those are the two main ones that we'll talk about. There's also prohibitions in the prohibition in employment of relatives, the Nepotism Act, as people refer to it, that we want to go through because, again, that's really more of an ethics issue. It doesn't harm anyone, directly when a family member of yours is working for you, you're their supervisor, but it feels wrong to the legislature, so you can't do that. So we'll touch on the Nepotism Act quickly, and then also the Utah Procurement Code has a section called the Unlawful Conduct and Penalties section, which clearly, again, it reiterates some of the offenses that show up in others. And then the Offenses Against Administration of Government, Title 676, also has several items that are prohibitions to government employees that you cannot do, and that others can't do with you as a government employee. It's not, again, there are lines here and then throughout the code that will restrict public officers from doing certain things. And in your own, if you're an elected official, in your own code that spells out the duties of the recorder, the clerk, the auditor, there will be things there that will prohibit you or limit you in doing certain things in that particular office. So you'll want to watch those as well. We're gonna hit the top ones today because that's going to take us enough time that I don't expect that you'll be lively enough after getting through this to talk about each individual office. So we'll start with the Ethics Act, the Public Officers and Employees Ethics Act. This act prohibits acts of officers and employees and prescribes penalties for those violations. And remember, when we talk about employees, that also encompasses volunteers. Because in Utah, a volunteer to a government agency is not a volunteer. They are a pseudo-employee. They have many of the same rights and requirements and responsibilities as an employee to the government entity. We'll start with the penalties, because I always find that people pay much more attention to this presentation if I talk about the penalties first, rather than leaving them for last. All the violations under this act can be brought before that political subdivision's ethics review committee, and again, that will not be a fun process for you if you ever have to do that. You're going to miss time from work at your own expense to go to their hearings and spend as much time in front of them and explain things until they're satisfied. You give them whatever information they request. They're going to subpoena your friends and relatives and business partners and all of that sort of thing. So it will not be, and the other problem that we found with them is they like to give a lot of information about what they were doing and talking about to the media, which shouldn't be the case. Those hearings should be closed until a determination is made. And actually, even the section of the statute that creates the committee has some information about if somebody alleges that you violated the act, Rodney, and they go to the newspaper and say, Rodney's violated the Ethics Act, because they've already more or less tried that case in the media, they don't get to go to the political subdivisions committee any longer, says the statute. But even though in this one case, the public official, it was well known, people had been complaining about the things that he was allegedly doing in his office, and it had been in the newspapers, the committee felt that it wasn't enough in the media that they should still hear the case. Again, it would be better to have them go to a good committee that understands the law and not have that all in the media until there's a determination made, but that might not be the case. All violations in this section, actually all the violations in this Ethics Act requires that you are discharged from your office or terminated from your employment. The county does not have a choice. The statute requires them to terminate you. How they expect to terminate an elected official, there's no explanation. There's no process. You can't terminate an elected official. There's one section of the statute that allows for a person to go to a judge and provide evidence, and then the elected official can come back with evidence that they didn't commit the violation that they supposedly have committed, and the judge will make the determination if they are going to be terminated from their office or not, but rarely happens. We all know that from the Gary Ott case, right? So how they expect to do this with an elected official is problematic. With an employee, it's pretty simple. The county must terminate them. And with the exception of 67-16-6 and 67-16-7, which is when you're doing business or you have an interest in another business that is regulated or does business with the county, with the exception of those two, all the others are going to range from a second-degree felony to a Class B misdemeanor. So they are all criminal charges as well as losing your job. And for those couple of 16-6, 16-7, and 16-8, if there's a violation there, the county can rescind or void any contract that was entered into as a result of those violations. So you owned some interest in another business that got a contract with the county, you didn't disclose that, you're in violation of 16-7, the county can void that contract. They don't have to pay any of the money back they don't have to pay for the services rendered to date, and the contract is null and void. So not only do you lose your job, you potentially got some penalties and jail time, and your business just lost a bunch of money. So pretty severe penalties. All right, are we all awake now? Start out here with disclosure of controlled information other than for other employment. So you may not accept employment with another company if what they want to hire you for is that you're going to take protected information, non-public information that you have access to as a county employee and funnel it to that new company that you're working for. That is a violation of the statute, and that improper disclosure of controlled information, you'll find that you can't do that anytime, but they clarify it here that you absolutely cannot do it for a business that you work for outside of the county. Then there's just disclosure of controlled information for economic interest or special privilege. So now you're not working for this other company, but they're going to pay you something or give you a gift of some sort, or they're going to give you some special privilege that other people don't have because you are getting non-public information from the county and giving it to them. Okay? And some of you in some of the offices that you have, there certainly is non-public information that there are companies out there that would love to have. And just be careful about ever giving that information. If you have another job where they want you to get some information because you know the ins and outs of the county and you know what information the county has and it's public information, that's not a violation of the statute. But I'd be very careful about how you get that public information. Don't just go to your supervisor's desk and make copies of the information from off their desk. Go through the normal channels, go to the county website, make a grammar request, the same as any other person, the general public, would get that public information and then provide it for the other company that you work for or this other company that wants to give you some special privilege for getting them that information, because it would take them longer to figure out that the county has it and what department has it and what format do they have it in, and those sorts of things. Okay? Use of position for economic interest or special privilege. This is kind of the all-encompassing one that if you use your job with the county to substantially further your own personal economic interest or secure some special privileges or exemptions for yourself or others, meaning your family members, that is a violation of the statute. So again, if it's something that anybody else that's not a public employee could do and make money at, not a problem. But if the only reason that you're making money at this other business or other interest is because you're a county employee, that's where now you may be in violation. Okay. Other employment impairing judgment. So again, if the other employment that you might take on would potentially impair your judgment in your capacity in your official position, that is a violation of the statute. So for typical employees that don't have a lot of decision-making capabilities, aren't approving or denying permits and things like that, probably not going to get in this situation. But certainly, once they get to a staff member in the Planning and Zoning Commission that is making those types of decisions, a supervisor or department head that makes decisions on contracts and purchases, and certainly the commissioners, any other employment that would impair their judgment here in the county is potentially a violation here under this section of the statute. Okay? Pretty broad. Other employment interfering with ethical performance of public duties. So again, you cannot accept other employment that might expect, that you would expect would interfere with your ethical performance of your public duties. So again, if it's an employment where the basis of that business is counter to the county's mission, and you're going to do that job, clearly that would interfere with your ethical performance in your job. A reasonable person could consider that it would be a violation of the statute. And again, in the statute it talks about whether you or a reasonable person would. And usually when they talk about a reasonable person in the statutes, they're talking about a jury. And take it from me, after 20-some years of doing this and reading through the decisions that are found against the counties, I'm not so sure that juries are all that reasonable. They don't recognize some of the hurdles that county government has to go through just to get their daily job done. The gift prohibition is a big one that most people do know, that you can't take a gift as a county employee in payment for giving somebody a special exception, right? But let's make sure that we understand it well here this morning. Economic benefit tantamount to a gift includes a loan at an interest rate substantially lower than the commercial rate, or compensation received for private services rendered at a rate substantially exceeding the fair market value. So if somebody's going to hire you to do a quick little job and pay you 4 times what they could pay somebody else to do it, but you're also going to help them out with something with the county, that is a gift. And certainly any monetary amount is a gift, but these two are ones that add to what you would typically consider a gift. Okay. A gift does not, though, include a non-monetary gift having value less than $50. And this one, again, the legislators like to be taken to lunch. It happens every single day. So they want to make sure that people who want to take them to lunch can do that, and they can accept that gift as long as it's less than $50. Now, many will tell you that the intent is from any one person or company, that's a $50 limit annually. And you can't take more than $50 annually from any one company. So if you're supervising a contractor with the county, making sure that they get their work done right under the contract, and they're stopping off, meeting you at the cafe to go over the work progress over lunch, and they're purchasing your lunch, just be careful that the total amount over the course of the year doesn't exceed $50. Okay? Yes?
Didn't they just change that rule not too long ago? Or I'm just going off memory, but something like a $10 lunch or something like that?
Yeah, they did put within the $50 that no one can exceed 10. Yes.
Somebody asked you a question. Can you repeat the question?
Oh, sure. So the question was, didn't they change that from 50 to 10? And they did sublimit any one gift, non-monetary gift, to $10 with it, for the total being 50 because, and I forgot about that. Thank you for reminding me that, because I think they did that in 2016. Because there was a lot of confusion over $50. Oh, you know, there are some commissioners that are like, $50, really? You know, so I'm not going to get my gold watch from the from the construction company that the county has used, and every other commissioner's gotten a gold watch when they retire. So they clarified that it is $50 a year, and any one lunch can't be more than 10. So yeah, the quick little luncheon at the cafe is okay, but you know, the steak dinner downtown is not going to cut it. Don't let them pay for that. Unless it's an award publicly presented in recognition of public service. So that contractor gives the commissioner a gold watch in front of everybody. Oh, yeah. Aren't you? Yeah, definitely. Yeah. Yes, you should. To be safe, you should pay your own way. But if they give that gold watch at an open public meeting as thank you for your service to the county, we appreciate it, then it's not a gift. People need to know that they're getting it. A bona fide loan made in the ordinary course of business at the usual interest rate is not a violation, and if you receive a political campaign contribution, that's not considered a gift. And how many county employees do you know that get political campaign contributions? Versus how many legislators do you know that get political campaign? So again, they carve out some exceptions for themselves. But again, some of the commissioners and other elected officials might have that happening, that people are giving them campaign contributions. That's not a gift. The other thing to be careful with when it comes to gift is that accepting doesn't mean accepting in the usual terms. It doesn't mean that you actually got it. It means that you received, accepted, take, seek, or solicit directly or indirectly for yourself or another person. So the fact that they don't actually give you the gift, but you ask them for it, is a violation of the act. The fact that they don't give you the gift, but you had your spouse ask for it, is a violation of the statute. The fact that you didn't receive the gift, but your spouse asked for the gift for your son, is a violation of the statute. Okay? So again, be really careful with gifts. The little trinkets that you pick up at vendor tables and things at the conference, again, they're not over $10. Everybody's very careful with that. So that's not what they're after here. But certainly, you know, gift cards, $100 gift cards and things like that are things that, you know, I get them from the law firms that we work with. They just send them out to all their clients every year at Christmas. $100 gift card, thanks for your business. Send them back every single year. Can't accept it. Okay? So don't think that you can get around by having somebody else ask for it or having it go to somebody else. It's still a gift, and it's still a violation. So accepting a gift that improperly influences faithful discharge of duties. So anytime that you accept that gift, and the idea, a reasonable person would tend to think that that's going to influence the way that you do your job in your capacity at the county, that's when it's a violation of the statute. And again, a reasonable person, a juror, is going to take that pretty far. They're going to assume that, yeah, well, why would they be giving you a gift except for they want you to do something for them because you're a county employee. Doesn't mean that you can't, if your uncle owns a construction company and he gives you a gift at Christmas, not a big deal. But if he gives you a special gift at Christmas because you're doing something for him at the county, that's where you're going to be in trouble. Accepting a gift as a reward for official action taken. So again, we're talking more about the officers, the elected officials, and the commissioners, that they're going to take an official action of the county, and they accept a gift in exchange for that official action. Clear violation of the statute. Accepting a gift without providing a disclosure. So here, it seems to give an indication that some limited gifts are okay, as long as you disclose that you've received the gift. So you may not accept a gift if the public officer or public employee recently has been, is now, or in the near future may be involved in any governmental action directly affecting the donor or lender unless a disclosure of the gift, compensation, or loan and other relevant information is provided. So somebody who's not in front of the county right now for any permit or action that they want the county to take that is giving you as an elected official a gift, if you disclose that you accepted that gift at the time that now they are asking for something, supposedly you're okay. I still question, wouldn't you still be guilty of accepting that gift from the earlier provisions? So I'd be very careful with this one, that if you're accepting a gift from someone and you can see that it only is because of your position within the county, and that at some point they're going to be looking for some kind of payback, you can do the disclosure, but you might still have violated the act under another provision. This is where it gets really kind of fuzzy. I'm not sure. And of course, these sections were written at different times. So requiring donation, payment, or service to government agency in exchange for approval. So I used to see this happen all the time, 10, 20 years ago in government, that, okay, we're going to approve your permit, but we want you to donate money for the fireworks at the 4th of July celebration. How does that sound? Oh, yeah, okay, we'll do that. Can't do that here in Utah. As an employee, an official, or as the county, you cannot coerce someone to provide a donation or pay them for a service at a special rate in exchange for approval of any type of a permit or a variance or anything like that. Okay? The exceptions to that are if that exchange is required by statute in order to approve the subdivision, they have to provide some land for a area park or for road or something like that, then it's okay. Or if it's mutually agreed to between the applicant and the entity, and if you go into the statute, you'll see that if it's agreed to and they're okay with giving the donation, they aren't troubled by it at all, it's only okay if they make written statement that's disclosed at public meeting. So there is a process that they have to go to make that donation and clarify that they weren't coerced into providing it.
Like a development agreement, fall into that?
Yes, yes. So it's not required by the statute. It isn't part of a condition or consent decree or settlement related to an action that's between you and that contractor or developer. Again, they can say, yes, I'm giving it voluntarily. I understand that I'm still going to get the approval even if I don't give this donation. They do all that in writing, sworn statement, then it's not a violation. So the county can't require it of someone, and someone may not offer it. So if the developer is coming to the county and saying, if you approve this development, I will donate the money for the fireworks for the 4th of July, that's a violation of the statute. And they are subject. Of course, you can't terminate them from their job, but they're potentially anywhere up to, if it's over $1,000 gift, which fireworks would be, they've got a second-degree felony facing them. Okay? And the same exceptions apply here. Personal investments in a business which creates a conflict. So if you have investment interest, you're an officer of another business, you're an employee of another business, you own stock in another business, that creates a conflict between that business and the work that you do as a county employee, that's a violation of the statute. So you need to be careful with that. What creates a conflict? Again, conflict of interest is kind of a gray area, so you'd want to be very careful on how you would do that. And when we talk about personal investments, if it just so happens that the 401k that you are involved with or that you have that you have managed by a 401k manager happens to own an interest in one of the big architectural firms or engineering firms that the county is doing business with, I wouldn't see that as a violation. If you're investing directly in that company, then you are in violation. Okay. Inducing others to commit a violation of any of these sections is also a violation of the Act, and all the way through these now, all of these that we've talked about so far, you lose your job, lose your position with your official position with the county, and you at least a Class B misdemeanor up to a second-degree felony, depending on how much the value of that action accounted for. Okay. These next couple again are the ones that are exceptions that there's no criminal charge. You're still going to lose your job. There's no criminal charge, and any agreement that the county entered into as a part of these can be considered null and void. So compensation for assisting in a transaction with the agency. So you may not receive or agree to receive compensation for assisting any person or business entity in any transaction involving an agency unless the public officer or employee files in a sworn written statement what their interest in that other entity and what compensation they're receiving. So because you know how the process works to get a permit through the Planning and Zoning Commission, because you've been around the county long enough, someone wants to pay you to help them get through that process because they need that permit quickly. You can only do that if you provide a sworn written statement to the county that you are receiving compensation to assist that person in their transaction with the county. Okay? And again, because these apply to all types of government agencies, that's why it's agency, not county. Failure to disclose substantial interest in a regulated business. So now we're talking about a business that the county regulates in some fashion, and you have an interest in it, and you failed to notify the county that you had an interest in that business, you're in violation of this section of the statute. So your family owns a restaurant in town, somewhere in the county. Restaurant's regulated by the county health department, right? You have ownership in that restaurant. You need to disclose in the and this one is you need to do this one in writing, and you need to provide it when you either take office or you take interest in that other regulated business, and any time that your interest in that business changes. So right now you and two of your brothers own the restaurant. Down the road you purchase your brother's shares, and now you're the sole owner of the restaurant. You need to refile your statement because your position with that company changed. So be careful about businesses that are regulated by the county. Participating in an official transaction with a business that the officer or employee has an interest in. So again, if a business that you have some interest in has an official transaction going on with the county, you need to make sure that you have disclosed that your interest in that company at the time that transaction is taking place. So this one, I would recommend that you file a written statement that you have interest in that other entity, because you know that at some point they're going to have a transaction with the county. But you would also want to, when that business is being discussed by the county or a committee of the county for a transaction, that you disclose it at that meeting, at that open public meeting as well. That, hey, just to remind you all, I'm part owner of this business that you're looking at tonight, so I just wanted to make sure that that's disclosed, and then you should be okay. Okay, questions on the Ethics Act? All of those things, you're losing your job, you may go to jail. The Disclosure Act, County Officers and Employees Disclosure Act in Title 17, has to do specifically with counties. And this is, again, where it gets really weird, because this section was written by a different legislator at a different time than the Ethics Act was written. So there are some things that double up. This act, while it does have some prohibited acts again, they're the same prohibited acts that we already talked about in the Ethics Act. What it has to do with more is the actions that you, or the situations you'd get in where you'd have to make a disclosure of your conflict of interest or potential conflict. Some disclosures need to be made annually in writing. Others need to be made at a certain time when that other business or other interest is being discussed by the county. So again, you want to make sure that you're doing the proper disclosure. Myself, I make sure that if it's required for me to make the disclosure at open public meeting, I just file a written statement as well, just to cover my base. Because I don't know when they're going to change this. Oh, well, I know when they're going to change this statute. But if they change one of those from just doing it at an open public meeting to a written statement, and you didn't happen to catch that they changed the statute, you'd be in trouble. Again, a lot of these you'll find are the same things we've already talked about. The problem is you're already losing your job. You already have potential for criminal charges under the Ethics Act. Now you're going to stack the penalties under this act on top of that. So all violations, again, can be brought before the Political Subdivisions Ethics Review Commission by anyone. It doesn't need to be someone with authority to make the allegation. Anybody can make the allegation. Violations require removal from office or employment and charged in this section with a Class A misdemeanor in addition to any other provision of law. So Class A misdemeanor on top of whatever you got under the Ethics Act if it appears in both. And if a transaction is entered into under Section 6, again, the county can rescind and void that contract entered into without returning any part of the consideration received by the county. So again, just like we had in the Ethics Act, you cannot use your official position to get special compensation or special exemptions or privileges. Okay? You cannot disclose confidential information, the same as in the Ethics Act. You cannot use your official position to secure special privileges or exemptions for yourself or for other people. And you cannot knowingly receive, accept, take, seek, or solicit directly or indirectly a gift or loan for the officer or another if the gift or loan tends to influence the officer in the discharge of his official duties. So again, the same things that are violations in the Ethics Act are violations here again, and they're just going to make life even more miserable for you. Compensation for assisting in transaction with the county. Again, if you are doing business, if someone wants to pay you to assist them in doing some business with the county because you know the ins and outs, that's okay as long as you disclose it and you're being paid a reasonable amount. That's the slippery slope here. If they're paying you a going rate for some consulting services, okay. If they're paying you triple the normal consulting rate to do it, then you're back to into the Ethics Act where that's really considered a gift. Interest in a business regulated by the county, just like we talked about the restaurant. Again, if you have that interest in that regulated business, you need to make sure that you're disclosing the position that you hold and the type of interest that you have in that business upon taking office with the county and every January. So if you have interest in a business like that, whether or not you think they might ever do business with the county, it might be safer just to disclose that each January in your conflict of interest statement. You know, for our board of directors, we have them do a conflict of interest statement every single year. And whether or not they have any interest conflicts or not, they're going through that and signing off that they don't have any. And again, if they do, that doesn't mean that they're prohibited from doing any certain thing. It's up to the rest of the commission or board of what they should and should not be involved in as far as discussion and decision making. Interest in a business doing business with the county, you must disclose that as well here. And again, as long as that other business interest that you have doesn't make you, doesn't interfere with your faithful performance as a county employee, it's okay as long as you disclose it. Personal investments in a business which create a conflict, just like it was in the Ethics Act, here you need to make sure that you're disclosing it, and in the Ethics Act it said the same thing. You need to disclose that. Otherwise it's a violation. So here's the quick cheat sheet, again, because these are important and the ones I get the most questions about. If it's doing a transaction, file a sworn statement, and any time that transaction is being discussed, at the open public meeting that it's being discussed at, you should disclose it again in that open public meeting. Remember that I'm an officer of this company. An interest in a regulated business, file a sworn statement every January. Interest in a business doing business with the county, disclose that in an open meeting anytime that they're discussing that other business. And personal investments which create a conflict, you need to discuss in the open meeting prior to the discussion. Okay? And all of these, again, if you think you might be in this situation, seek out legal advice. I'm not an attorney, but you should seek out legal advice and make sure that you're not in violation. Inducing an officer to violate provisions of the, that are prohibited. So again, if someone tries to talk you into violating any of these prohibitions that we've talked about, they are guilty of a Class A misdemeanor under this section and potentially a Class B misdemeanor or more under the Ethics Act. All right, questions on those? A lot of duplication there. Next, we'll go to the Nepotism Act. Prohibiting employment of relatives is how it's referred to in the statute under Title 52. The purpose is to make sure that county government jobs are open to anyone, not just to family members. And again, I mentioned that after high school, I went to the university, got my degree in law enforcement, and while I was doing that, I also took some classes on to be a potentially be a firefighter. Well, when I got done with all my classes, moved back home, and wanted to seek employment with the county. At that point, 35 years ago, in the county I lived in, Minnesota, if you didn't have the right family name, there was no way you were working for the county sheriff or for the fire department. That's the only way you got into either one of those departments, is to have the right family name. And I didn't have the right family name. There was no way I was ever going to get a job in either of those departments in the county I lived in. And that's the way it was until these nepotism acts were passed. And in Utah, it's a pretty significant, pretty severe act in that it restricts a lot. First of all, just what a relative means. In a lot of other states, it's much closer family definition than what it is here. It's father, mother, husband, wife, son, daughter, sister, brother, grandfather, grandmother, uncle, aunt, nephew, niece, grandson, granddaughter, first cousin, mother-in-law, father-in-law, brother-in-law, sister-in-law, son-in-law, or daughter-in-law. Is that everybody that you know? I mean, in some counties, there's no way, if there weren't any exceptions to that, that they could have anybody working for the county, because everybody's going to fit that definition. What the statute does is it restricts employment or appointment. No officer of the county government or any government can employ, appoint, vote for, or recommend the appointment of a relative in any employment paid from public funds if the employment will be supervised by a relative. So even if it isn't the commissioner's relative, if the commissioner knows that this new employee is going to report directly to their uncle, it's a violation for the commissioner to appoint that person or hire that person into that job. And everybody else who's involved in the hiring of that employee has violated this act. HR, for recommending that person, is in violation of the act. So there's first the prohibition against hiring people into those situations. An appointee may not accept or retain employment. So the person accepting that position that knows that they're going to be working under the direct supervision of their uncle is in violation of the act, and is going to lose their job immediately and be subject to potential criminal charges. The exceptions to the employment are, so if the appointee is qualified through a civil service or merit system, if you have that system in your county, that can be an exception to the rule, that they can still be an employee. The supervision is still a problem, as we'll see in a minute. The appointee is paid from vocational training funds, so if they're paid out of a grant from the university, extension service, something like that, that can be an exception where they can take the job, but you're going to have some issues with supervision. Employment is for a period of 12 weeks or less, so a temporary employee can be supervised by a relative under certain conditions. Or the appointee is a volunteer, or the chief administrative officer, which here in the county would be the chairman of the commission, the current chairman, determines that the appointee is the only or the best person available, qualified, or eligible for the position. That's a pretty high hurdle to get to in a county the size of Box Elder, that they are really the only person that is qualified. Okay, so here's the exception. The same exceptions apply for the direct supervision. So we've looked at those exceptions. They can be an employee. There's exception to having direct supervision if the relative was employed prior to the supervisor assuming the position. So two employees work in the same department. They're both just regular employees. One of them gets a promotion to supervisor and now supervises their family member. Because they were first just co-employees, that's okay. That supervisor can be their supervisor and not be a violation of the act. Again, but some of the supervisory duties have to be amended. Or if if they're part of a civil service or merit system, that's okay. There's an exception for that. They're paid from vocational funds, or the employment is less than 12 weeks. The employee is a volunteer, or they're the only person available, qualified, or eligible for the position. Then again, you can have that supervisor relationship with the family member. Here's the catch. You have to have disclosure. So the supervisor now, either when they're promoted or when a family member is hired as their employee that they'll supervise, first of all, they have to meet one of these exceptions, or they violated the act even by hiring them. If they meet one of these exceptions, the supervisor has to complete a written disclosure of the relationship to the employee and an appointee to the commission chair. Okay? After they make the disclosure, the other thing is the supervisor cannot evaluate the performance or recommend salary increases for that employee. Two pretty important parts of supervising, right? So you can supervise that person day to day, but when it comes to their annual review or semi-annual review or whatever they do in Box Elder, you can't do that evaluation of your family member. Someone else has to do that evaluation. Dang it. Don't get to do your evaluation. That'd be the one evaluation I'd want to do, the one for my son-in-law. You know? And you can't recommend salary increase. So you need to take yourself out of that piece. Now, the county is approving an overall 1%, 2% COLA for all employees. Probably not a problem. But merit increase, specifically for that specific employee who's the family member, the supervisor cannot be involved in that. Okay, so it needs to be passed off to somebody else. So there are ways to be able to deal with that. The exception in towns, if you were a township, then the definition of family members, aunts, uncles, nephews, nieces, and cousins get taken out of the mix. The other exception is for rural areas, so employment of a relative restrictions, they don't apply if there's less than 30,000 or 3,000 people within 40 miles of the place of employment, and the job opening had a reasonable public notice and the relative is the best qualified candidate. So you got to meet those two standards. So if you have a highway shop out on the west end of the county and there's less than 3,000 people within 40 miles of the place that that individual is going to work, then there's an exception again to the restrictions, and you can hire that person, but again, if the supervisor is supervising them, that is the family member, they can't do the evaluation or recommend salary increase, but they can work for them, okay? Here, any violation is a misdemeanor. Misdemeanor on top of anything else that was a violation somewhere else. And even though a misdemeanor doesn't sound like much, it's a misdemeanor for every single day of the violation. So if you've had your niece working in your department under your direct supervision for the last 2 years and just found out that that's a violation of the act, every single day is a separate misdemeanor. So it stacks up pretty quick. So if you get in this situation, you don't want it to go on very long. Questions on the Nepotism Act? Okay. In the Purchasing Act, the Utah Procurement Code, again, the state procurement code is meant to be all-encompassing for all state agencies on how they purchase things. It also allows counties to adopt portions of that act if they choose to, or they can circumvent the procurement code by having their own separate ordinance on how they're going to do procurements. But most counties that I've seen, their purchasing ordinance, procurement ordinance, is very similar to the procurement code in that it prohibits people who are in that decision-making process from taking gifts. And we know that even if it isn't in your purchasing ordinance here in the county, it's still a violation under the Ethics Act and maybe under the Bribery Act that we'll get to in a second, that you're already losing your job and going to jail for. Just know that if you're part of the purchasing decision-making process, that again, taking gifts or asking for loans at a special rate, any of those sorts of things, adds additional charges to the long list of things that you're already guilty of. Okay. And again, if it's more than $1,000 procurement, second-degree felony. Again, you need to look at your own procurement code, but that, just because it's not a violation of the Box Elder County Procurement Code doesn't mean that it's not a violation under the other sections of the statute. Doesn't exempt you. And lastly, there's the Offenses Against Administration of Government, Title 676, which in it has Chapter 8, which is corrupt practices. That I find that most people don't know about this one. This is the bribery statute. Bribery or offering a bribe is a violation of this statute to any kind of an official or employee of a government agency. Threats to influence official or political action, so someone threatens you that they want you to take a specific action, or they're going to ruin your business or break your legs or any type of threat. It's a violation of this statute. So you do have some recourse. Receiving or soliciting a bribe or bribery by a public servant. So if you do receive a bribe, first of all, it's a gift under the Ethics Act and the Disclosure Act, and here it's a bribe, so you're going to get additional charges added to the list. Receiving a bribe or bribery for endorsement of a person as a public servant. So if you're bribed, given a gift to get somebody hired, somebody wants their family member hired into the county, or they want to be hired into the county, and you're going to endorse that hire and get a gift for it, that's a bribe under this statute. Alteration of and then the last ones are for legislators and police officers, so I'm going to skip those. And again, I go through these, but again, you get the idea, right? Again, this is a summary only of those 4 major areas of ethics. Again, there'll be little bits and pieces in different sections of the statute, but most of them fall along these same lines. If you have an interest in a business, if you're going to get paid for doing work for somebody with the county, or if you're accepting a gift, you're probably in trouble. So if you get into any of those types of situations and you want to see if you can move forward, talk with an attorney, have them review the pertinent statute and determine whether or not you can do it with the proper disclosure. Okay? But I would always recommend do as much disclosure. If you even question it, disclose it. At least that's going to be some defense if you ever end up in the political subdivisions ethics committee. Okay? Thanks for your time. Appreciate it. Any questions? Great. Thanks.